26-year-old Tyler Harding has been charged with 31 offenses, including burglary, larceny, hit and run, assault with a deadly weapon, and fleeing or eluding arrest.
I am going to honor the request from the state in terms of raising the amount of the bond.
After hearing the judge's decision, Harding, who's been raising his hand throughout the hearing, seems like he's heard enough.
So, this. Hey, I'm letting it back. Nah, I'll let him finish.
Hold on. One thing you're not going to do is give me permission to do anything. I already have that, so I don't need your permission.
No,
so you can go. No. You can go ahead and leave. You can go ahead and leave. You already upset. Go ahead and leave. Go ahead and leave.
For the arraignment of Tobias Roman.
Go and stand up.
I'm full of her, so I can't stand up right now. Am I right here?
His initial hearing is off to a rocky start.
Stand up, Roman.
Yeah, what?
Mr. Roman, what is your true and correct name?
Tobias, my first name. That's it. Giggles or Tobias. That's it. Don't call me nothing else.
And the charges, Mr. Roman, are attempted robbery.
It's all right.
Hey, Mr. Roman, you need to be quiet.
Yeah, you need to be quiet.
You got one more chance, and then you're going to be removed from the courtroom.
I'm talking. Go over here.
You need to leave.
But as he's being led out of the courtroom, Roman gets in the last word.
I'll murder you when I see you.
The judge heard that comment loud and clear.
Statement on the record that he will murder me if he sees me, and I'm going to request law enforcement to take the appropriate action.
Court. You know, I have other things going on in my life. People make mistakes in life. Sorry, I'm not perfect.
40-year-old Roxanne Jallow has pled guilty to third-degree theft. A year earlier, Jallow was arrested for stealing over $1,500 worth of merchandise from a department store. She was given a 24-month deferred sentence with several conditions, including that she undergo a substance abuse evaluation. Today, Jallow appears before Judge Kimberly Walden because she's failed to complete the evaluation. She's represented by attorney Alyssa Furlong.
Ms. Jallow is saying she didn't fully understand that she would have to follow through with recommended treatment, and she has expressed that she would like to just address the court herself.
Okay, Ms. Jallow?
Yes.
So we're on for sentencing, and presumably you've had that substance abuse evaluation. I'm hearing that you have not done that?
No.
Ms. Jallow, are you telling me that you're gonna disregard the court's order?
Well, I don't want to do it. My thought on the deferred sentence is that if I didn't do it, I just didn't do it. I didn't know that I have consequences.
Consequences are is that you can get up to 364 days in jail for this.
I accidentally forgot about court. You know, I have other things going on in my life. People make mistakes in life. Sorry, I'm not perfect.
Well, I think that's what the parties were telling me by saying, yes, people make mistakes in life, so give someone a chance, or go get a substance abuse evaluation, follow through with a treatment recommendation, and have an opportunity to get your case dismissed. You don't have a clean criminal history. You have criminal conviction. So the recommendation for a deferred sentence by both of the parties is rare for someone with a criminal history.
That shouldn't even be brought up.
I appreciate that you're trying to think that you know how I should be doing my job, but that's not how it works. The bottom line is that if you're going to go off camera, you have to come on camera. Otherwise, I'm not going to allow you to.
Okay, what do you want me to do? Okay, I'll go get the drug and alcohol evaluation. I'm done with this. I'm done.
Before wrapping up, the judge decides to give Jallow one final chance.
I'm setting sentencing over, and you have to get a substance abuse evaluation between now and that sentencing hearing where you have to appear in person. And then we're going to see, based on that evaluation, what the appropriate sentence should be. Hopefully, still get that deferred so you can get that case dismissed. Your next court date.
Are we done?
We're not done. We're not done. Your next court date is March 13th at 10:30. You will appear in person at the Tacoma Justice Center for
I'll see you
sentencing
then.
with your substance abuse. Don't you dare hang up, Miss Jallow, or I will order a warrant for your arrest.
Well, I mean, what do you want me to do? You told me my next court date's March 13th.
What I'd
I'll
like
be
you to
there.
do, what I'd like you to do is act like you're actually in court. Do you want to speak to your attorneys before you hang up?
No.
Okay, come back March 13th here at 10:30 with the results of your evaluation so we can go forward with sentencing. You now are free to leave. Thank you.
After the hearing, Jallow got a new attorney who asked that her sentencing be rescheduled to a later date. Court granted the request, and her case is pending. She's recusing herself from the trial because she knew the two jail employees he targeted with his vehicle.
There's no way I'm going to try this case or have any further proceedings, or I'll have to see you for one further setting. Set for the review next week.
Watch again as Webb literally spit on the judge. But this incident is far from the last time Bass Webb will spit in the face of the law.
For you.
Yes, ma'am.
Did you go to Nautilus for middle school?
Oh my goodness. Oh my goodness.
I'm sorry to see you there. I always wondered what happened to you, sir.
Oh my goodness.
This is the nicest kid in middle school.
Oh my goodness.
He was the best kid in middle school. I used to play football with him, all the kids, and look what has happened. I'm so sorry.
Oh my goodness.
Are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking right now.
Judge Simpson appears confused.
So maybe I don't understand something. This is a driver with a license suspended,
That is correct, Your Honor.
and he was just driving, and he didn't have a license.
Oh.
44-year-old Corey Harris has been charged with driving with a suspended license. 15 years earlier, Harris had his license suspended for failing to pay child support. A court then rescinded the suspension in 2022, but according to the state, Harris never followed up with the necessary paperwork, so the suspension was never officially lifted. So when Harris was pulled over in October of 2023 and cited for driving with a suspended license, he was given a no-cash bond and ordered to return to court at a later date. Today, he's scheduled to appear before Judge Cedric Simpson to discuss next steps in the case.
Court calls case People versus Corey Harris.
Harris's attorney announces herself.
Assistant Public Defender Natalie Tate for Mr. Harris, who should be present is due.
Harris joins the hearing, although it looks like he's in a car, driving.
Hello?
Are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking right now.
Judge Simpson appears confused.
So maybe I don't understand something. This is a driver with a license suspended,
That is correct, Your Honor.
and he was just driving, and he didn't have a license.
Oh.
That is with the charges, Your Honor, yes.
No, I'm looking at his
Yes.
record. He doesn't have a license. He's suspended and he's just driving.
That is correct, Your Honor.
Hello?
1 minute, Mr. Harris.
I don't even know why he would do that. So, defendant's bond is revoked in this matter.
Now it's the defendant who looks confused.
So, defendant has turned himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond. Thank you.
Thank you, Your Honor. Mr. Harris, I'll be giving you a call.
Okay.
Harris turned himself in that day and served 2 days in the county jail. 3 weeks later, he had a new lawyer and another hearing where Judge Simpson confirmed that at the time of his last traffic stop, Harris was, in fact, driving with a suspended license. He was released on a no-fee personal bond and has yet to enter a plea. The case is pending. Harris did finally file the necessary paperwork, and his driver's license suspension has been lifted. Here for the official filing of his latest charges, and this time he's decided to show up. But it's possible he's unaware of his active warrant, and as he enters the courthouse, there are at least 3 officers there to greet him at security check-in. At first, he appears to be cooperating. But when the officers receive instructions to take him into custody, Coon gets spooked and makes a run for it. As the officers surround him, Coon bolts for the door. Several officers pursue the defendant, but he's too fast for them. Coon makes it to a tree line and disappears. Going as planned, until the judge asks the prosecutor if he also agrees to waive the probable cause hearing.
People also waive their right?
Your Honor, I'll agree to waive, but I do want to make a statement on the record. It appeared that earlier in this time block that Mr. Lane was rolling a blunt and might have been smoking.
Your Honor, given that information, I guess we need to adjourn the PCC so Mr. Lane and I can speak further before we wait.
Yeah. I think that might be wise. Mr. Lane, you understand what's happening now?
Yeah.
As part of his bond conditions, Lane is also supposed to be taking regular drug tests.
When's the last time you tested?
2 weeks ago.
You were supposed to be testing 2 times per week.
I tested back to back.
Okay, but have you tested this week?
No, sir.
I'm also going to order that you're to report to Community Corrections today for a test.
Your Honor, I have no ride today.
Well, you better find somebody to get you a ride down here.
It appears now that Grazer's calmed down, but moments later, he somehow has slipped through the slats at the top of the bulletproof security dock. A gap in the video doesn't reveal how he did it, but if we look again, officers consider opening the box to stop him, but Grazer's way ahead of them.
You need to put a shirt on, or you're going to be removed from the meeting.
But when the judge calls his case minutes later, Lester is still shirtless.
State of Michigan versus Derek Lester.
Yes, I'm here, Your Honor.
Mr. Lester, put a shirt on.
Give me 1 second. All right, I'm ready. I'm ready.
Mr. Lester, this is still a courtroom, so please, in the future, put on an appropriate shirt for court.
I am. I'm so sorry. I just got out the shower. I'm sorry.
The judge decides to just move on.
Sir, if you can't afford an attorney, the court can appoint one at the public's expense. Would you like this of an attorney?
Yes, you can appoint me an attorney.
Okay.
The judge calls on Public Defender Brian Crago, who's in the virtual courtroom for other defendants, to represent Lester for today. They go into a private breakout room to briefly discuss his case. When they return, Lester has a more appropriate shirt on, but now it's his headgear that catches the judge's attention.
Mr. Lester, you need to remove your hat. This is still a courtroom.
The driver's seat.
Looks like the back seat to me, but
I suppose, Judge, if he could just turn his camera and show that he's in the back seat, that would be enough to satisfy me. I don't know if Mr. Banis wants to instruct his client to do that yet.
Mr. Banis, yeah, this is your opportunity.
Your Honor, if we could have a breakout room, then I think I could at least make some representations to the court about what I believe is going on.
When Carter and his lawyer return from the breakout room, the prosecutor notices something a bit different about Carter.
Judge, he's clearly in a different seat. The
prosecutor seems annoyed, but he'll still offer Carter a plea deal.
He can plead to no ops on person at this time.
No operator's license is a lesser charge, but it would still be added to Carter's driving record.
I got a question, ma'am.
Oh, hold on, sir. I'm going to advise you not to say anything.
Okay.
Of course, there's no evidence that he's driving, but prosecutor has the ability to make whatever offer he feels is appropriate. So, Mr. Carter, if you want to resolve the driving while license suspended misdemeanor, you could plead guilty to a slightly less serious misdemeanor called no operator's license on person, which has 0 points. And I would ask the judge to sentence you to a fine. Are you interested in that?
No, I'm not.
Motion to withdraw due to a direct conflict of interest regarding a witness or potential witness in this case that I identified after meeting with Mr. Haywood. As a result, I am unable to continue to represent Mr. Haywood. I would ask the court to permit me to withdraw.
Okay, I noticed in the motion that I don't have the witness identified or the person identified.
Your Honor, if I identify the conflict who is not listed in the police report, he could be charged with crimes, and I've previously represented him. So I'm unable to provide additional information, which would result in discovery to the prosecutor.
Haywood's attorney finds herself in a bit of a legal pickle. She's aware of a witness in this case that the police have not identified yet. Trouble is, the person's a former client of hers, so identifying and thus potentially incriminating them would be a conflict of interest. But unless she does identify the potential witness, the judge may not be able to make a ruling.
I mean, I can't do it this way, Miss Julian. I mean, I have to have some indication as to what the conflict is.
She just told your stupid ass.
Haywood jumps in to defend his attorney, but his language is not exactly court-friendly.
She just told your stupid ass.
Mr. Haywood.
No, you didn't. Bond revoked. We're done.
With his bond revoked, Haywood will be staying in jail until his case is resolved.
Mr. Judge,
Bond revoked.
I'm unable to
continue. He will sit. This
Yes, Your
matter
Honor.
is adjourned to September 1st. Bond revoked. I'm done. You go talk to your client. He'll never address that court this way. His bond is revoked. You're still his attorney.
We head to Youngstown, Ohio for a preliminary hearing. 20-year-old Sean Peterson has been charged with complicity to murder. A month earlier, Peterson was allegedly involved in a fight between two groups. Multiple shots were fired, including one that hit 15-year-old Amaya Montserrat, which died later that night. Today, his attorney is asking the court to lower Peterson's bond. When the state and magistrate agree to the bond modification, the moment becomes too emotional for the victim's father, Jose Montserrat. Once Montserrat calms down, he's found to be in contempt of court and sentenced to 10 days in jail. Now just a few feet away from the man who so brutally took the life of his daughter, Sherelda.
Right now, I guess we're supposed to, in our hearts, forgive this clown who's touched our families, taken my child.
He's looking directly at Madison.
The offenses before the court, Mr. White?
Count 1 and 5, she's pleading guilty, Your Honor. Other
All
counts
right.
to be merged.
Ms. Walker, are you laying down in the bed? If you don't get yourself up, I will issue a bench warrant right now.
I'm laying down, I'm standing up. I'm leaning against the mirror. If I was laying down, I would have been way more comfortable. But
well, sit down somewhere, Ms. Walker.
As Walker's mother, the victim, logs onto the call, the judge checks in with prosecutor Sawana Hanvier.
Yes, Your Honor, the state was recommending 12 months to serve 2 days. Count 5 would be 12 months probation to run concurrent with count 1.
And Mr. White?
Your Honor, I just ask you accept the plea, Your Honor.
Ms. Walker, you're a mom, so you're going to experience a lot of what your mama has experienced. And if listen to me. If you allow your child to treat you,
that's not even,
ma'am,
the stuff happened with parents.
You're here for whatever I say you're here
not
for. I'm not accepting the plea. She's going to do jail time.
What do you mean? Because it's like you telling me
If
I'm a mom and
you keep talking, you're going to do more jail time. I need a contempt order, 20 days.
20 days.
Oh my God.
Charmaine, just be quiet. This is what everybody be talking to you about. Just be quiet. Just listen to her and be quiet.
She about to get 20 days for direct contempt before the court. And this is why you're having the problems that you're having. Because she thinks she's grown and that she doesn't have to be responsible to anybody. Anybody who attacks their mother and then thinks that they don't have to listen to a judge who's trying to put them on the right path, that's a problem. She ain't even good. She ain't even fit to be out here in polite society. I don't want her walking around because she's a danger to others. I don't even think she should have her child.
Walker responds by leaving the call.
Oh, so she signed off? Bench warrant. Get it for me. I'm not playing today. If she can't control herself enough to listen while somebody is trying to talk about the behavior that got her before a judge, that's a problem for me.
I'm sorry, Judge, because I wasn't trying to get in the way of
it's not
what you were saying. I was just telling her to be. I was just trying to tell her to be quiet.
I get it. As a mother, you're trying to save her from herself, but obviously that's not possible. But what she's not going to do is disrespect me or the process, and she's not going to have a tantrum on this. She's not. No, ma'am.
Walker soon returns to the call.
Miss Walker, you will find that life will be very, very hard when you go forward the way that you're going because you're so busy popping off at the mouth. First of all, it's rude. Second of all, you're raising a whole son. And if that's the way you're going to treat your mother, that's exactly how he's going to treat you. Are we clear?
Yes.
Everything that happened between you and your mother was choices you made. That's nobody else's fault, not mine or anybody else's. And I'll be doggone if I'm going to sit here and listen to you flip off at me like I'm the problem, like I'm the reason you're here. Do you understand what I'm saying?
Yeah.
So I still don't feel like you're a probation candidate, but I'm going to try it. Only for your mama interceding on your behalf. If it wasn't for your mama, you'd be going back to jail. But yeah, I'm going to try it. But the first mess up, all of this is going to come back. She loved her grandbaby, and that's my gift to her for putting up with your foolishness.
Thank you.
All right, take care.
Judge Hayward sentences Walker to 12 months probation. She must also pay a fine of $300, attend a family violence intervention program, and complete 40 hours of community service.
Drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Stop talking.
Things get off to a rocky start.
You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
The judge remains calm as Kimball continues.
We also had sent discovery out as laid out in our motion sometime back. We ultimately never got a response.
You got responses. Objection.
Hold on, wait a second. Ms. Stiles, you just need to object and then let me know what your objection is. Don't yell at her.
Objection to hearsay.
Hold on.
Judge Tenike presses the mute button on Stiles, allowing Kimball to speak without interruption.
And then we have an order to compel Ms. Stiles to provide dates for a deposition.
All right, so Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond.
Despite her disruptive behavior, the judge moves forward, attempting to get Stiles' responses to the 4 motions in question.
Do you have an objection to taking a drug test?
I use marijuana daily. All day, every day.
Okay.
So I'm glad to take the drug test. Okay, go. It's going to be on his expense, but
Stop. I'm pretty low key. We're in court. You need to be respectful. Just say Judge Tenike. Okay, it's pretty easy. So you use marijuana all day, every day?
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tenike.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
I'm not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. What's your response to their motion to compel?
Have you read their discovery?
Ma'am, you need to answer my question.
I answered your question.
All right.
By now, even this low-key judge seems to be losing patience.
So I'm going to warn you that it is completely inappropriate to swear like that in court.
Stiles then pushes her camera away. Turns to jail. She makes a subtle gesture towards the camera.
Who are you telling you love?
And the judge takes notice.
Did she just violate the court's order of no contact? Sit back down.
It appears Cargile mouthed, "I love you," twice. Perhaps in the direction of her boyfriend.
Who are you just mouthing "I love you" to?
No, I was just saying that I'm about ready to go.
No,
like I'm about done.
Ma'am, I can replay the tape. You
Okay.
said, "I love you." Who are you speaking to?
I love my lawyer.
Who do you love? Who did you?
My lawyer, like for having my back today.
No, come on.
It's like I like him.
Okay, so you love your attorney. You like
yes,
and you are mouthing to your attorney, to Mr. Paul, "I love you."
I was actually saying it to the guard as I got up.
You were saying it towards the camera as you got up.
I was like,
okay, stop. Mr. Lennon, is the co-defendant on here?
Judge, he's on here.
All right. Is Owen Sullivan your boyfriend of 5 years?
Yes, Your Honor, he is.
And you didn't know he was on here?
I can't see. There's a lot of different people up on the screen, and you were the big one.
Okay.
I was literally talking to the CO.
No, I don't buy that. You were looking at the screen. Your mouthing was very clear. See, this is why I can't trust you to have a bond modification. You just burnt some serious bridges on credibility with the court because you just showed me you don't have respect for the court. You don't have respect for your attorney, even though you claim he's the one you love. In any event, go ahead and leave. Go with the jail now. And just
thank you, Your Honor.
All right.
Cargile was later released on her $45,000 bond and has yet to enter a plea. If found guilty, she's facing up to 33 years in prison. As for Solomon, he was charged with possession of narcotics, possession with intent to use drug paraphernalia, and other drug-related charges. If found guilty, he's facing up to 11.5 years in prison. Both Cargile and Solomon's cases are pending.
Right driving with a suspended or revoked license, and you're sitting in the driver's seat of a car right now.
I had to take my kids to school.
Well, there's no take your kids to school exception to your suspended driver's license. You didn't show up for your arraignment.
Yeah, I was actually in the hospital. I had a kidney infection. I have all the proof for that.
After listening to Kelly's medical explanation, the judge moves on with the hearing.
So you had an unpaid ticket and you were going to pay it. So
Yeah, I just couldn't pay right then because I had been off work for my health issues, and then I had school that had just started back up, and I had to pay my household bills.
Well, and you're still driving, so that's not a good combination.
I have all the proofs for my vehicle, though.
Well, you don't have a license. Stop doing your hair. Try to pay attention to the fact that we're having a court case. I want you to have that stuff paid off. You need to make it a priority.
Okay.
All right. You're good to go.
All right, thank you.
Judge Middleton gives Kelly one more chance, scheduling a pretrial hearing a few weeks later. But she failed to appear, and the judge issued a warrant for her arrest.
So far, how am I doing?
Not bad, but you could do better.
Can we get a drum roll with this? I got to tell you, you brighten my day, ma'am. All right?
That's what the last guy said, and then he sued me.
I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court.
Michigan born and raised. She's a Detroit resident. She's a full-time mother with full-time custody of a 3-year-old daughter. She works full-time at Amazon at the Brownstown location. She's not sure if she still has that job, but she's been employed there ever since November. To my knowledge, she has no open criminal cases. She's not on probation. She's not on parole. Her iChat is clean. Her record of appearances in this court, she's never missed a date. She does not own or possess any firearms. She has no plans to leave the state of Michigan anytime soon. We know she has not been perfect while testing on bond. She has spent the entire week in jail. She had a lot of time to think and reflect on her mistakes. All this time away from her child. Her 80-year-old grandmother is struggling right now, trying to help take care of that child. Your Honor, I'm asking for a PR bond on her behalf, allowing her one final chance to show you that she has learned from her mistakes, and she personally would like to apologize to you herself.
I can speak. Oh, yeah. I apologize for the way my attitude has been perceived in this court.
Perceived?
I mean, I apologize. That's not who I am. I had a lot of time to reflect on my actions, and I learned my lesson. I don't want to be that person.
$10 days for contempt of court. You go now.
Hands behind your back.
You bitch, wait and see. You.
Shut your girl. Brace
Get my bracelet off the floor.
It's Cassandra Jackson. She's here today seeking a protection order, often sought by domestic violence victims. Unfortunately, a court official is telling her that she missed the deadline and will have to come back. Jackson, a working mother, grows increasingly frustrated. The argument's loud enough to be heard in the nearby courtroom. So loud that Magistrate Judge Michael Bachman, who's presiding in the courtroom on the other side of these doors, could not hear an attorney question a witness. Jackson continues to plead her case to the man in the hallway, but is denied. Jackson continues arguing before finally storming off. But Judge Bachman is unsatisfied and takes matters into his own hands. About 10 seconds after Jackson walks away, Bachman leaves the bench, chasing her down the hall. He catches up to Jackson at the elevators and orders her back to his courtroom. What happens next is critical to the eventual outcome of this story. As they head toward the court, Jackson tries to turn down a hallway. That's when Bachman grabs Jackson's shoulder. Even as they enter the courtroom, Bachman still does not remove his hand. Keep in mind, Jackson's in court today to file for a restraining order to protect herself and her children from an allegedly abusive relationship. Bachman orders Jackson into the jury box, then tells her she's about to be arrested for contempt of court. But the insensitive treatment continues from the rest of the court staff. 2 officers are brought in, and Jackson attempts to flee. Additional help's required to restrain Jackson. She resists. It is eventually removed from the court in handcuffs. The situation is taken to another level when Jackson's dragged to booking where formal charges are made. Officers handcuff Jackson to a chair as she continues to resist. After struggling with officers one more time, Jackson's strapped into a special chair and wheeled into holding, where she'll serve 2 days of a 10-day sentence after the presiding judge dropped the contempt charge and the rest of her sentence for good cause. After the footage goes public of Bachman chasing after Jackson and putting his hand on her, Jackson files a civil suit against Bachman, and the magistrate's told he must either resign or be fired. Bachman chose to resign. If Bachman needs to enter a Hamilton County courthouse in the future, he must now do so as a private citizen.
Yo, what up? What's going on? This your boy. What's up? What's going on with you? Yeah, we in the building today. We in the building for another episode of Courtroom Chronicles, man. How y'all doing today? Hey, can't complain, man. Beautiful day outside. Yeah, man. Yeah, all y'all that sleep out there. Yep. Open the door, man. Open the door. Wake up. Let's go. Let's see, man. How was y'all day today? I had a pretty good one today. You know, it's always a good day when you're working in business. You get out there, you do a little bit, you make a little money. You see what you can do. You know, see what you can do. See what's going on with out there. You know, seen a lot of topics in with YouTube land, from reproductive rights to should men be scared of women. It's all sort of stuff, man. All sort of stuff, man. All sort of wild stuff. But you know, it is what it is, man. It is what it is. You know, first things first, man. I want to thank Granville, man. Appreciate the 20 ball, bruh. But yeah, man, you know me, every now and again, I need a break from the monotony, man, from the monotony and everything. And that's pretty much what we do. What I think what we all do on YouTube. You know, that's what I think we all do on YouTube. We get a little break from the monotony, you know. Yeah. Different convos. And you know what I mean? That's pretty much what that's pretty much what we get over here and get away from. We get away from the monotonous of the everyday talk, the everyday everything, right? Right? See, yeah, I know how it is, you know. But yeah, man, I mean, look, Courtroom Chronicles is about seeing people act a fool in the courtroom. Yes. That's really what it's about. People acting a fool in the courtroom in a spot that you probably shouldn't be acting a fool in. Right? You probably shouldn't be acting a fool in the courtroom. That's the one spot that you shouldn't be doing it in. That's the one spot that you shouldn't be cutting the rug, cutting the fool, doing what you do. No. You do that shit outside. As we always say, take your ass outside. Go outside. Hey, that's what we always say. If you take your butt outside, you know, go outside, touch grass. That way you should be out there cutting the fool. By the time you get in front of the judge, you should kind of be cool. You know, it shouldn't be no big thing. You should be all right by the time you get in front of the judge. Right? But it's some of us that just don't know how to act when they get in front of a judge. They be in there doing all sort of stuff. Some people gonna be who they are regardless. If you're talking about a liar, some people gonna be a liar whether they're in front of a judge, whether they're in front of you, whether they're in front of their girl. They just a liar. This is what they always are. They just lie all the time. And you know, we've all met these people. We've all met these people. You were like, man, you this just who you are. It don't matter who you in front of. You could have seen them at school, they was tripping. Seen them at home, they tripping. In the streets, they tripping. It don't matter. These motherfuckers got to get their head busted down to the white meat to change. Now, have you ever heard of somebody who try to tell the judge that some drugs that was found on him wasn't his? These drugs in my pants ain't mine, Judge. Now think about that. You know, you're like, hold on, but they own you. You know, it's one thing for you to be like, oh, the car I was driving in. I can understand if you say that. The car I was driving in, man, no, that shit had shit in it. You know, but to say, oh, yeah, Judge, no. That shit that you found in my pants. Ain't man. Yeah, man, you really tripping at this point, bro. You really tripping at this point. So, you know, I don't know. Matter of fact, I don't think he tripping. Maybe he ain't tripping. Let me let y'all see. I'm gonna let y'all see what you think. Because he said they ain't his pants. Let's see if you think he plumb crazy.
My doggone pants.
What?
They weren't my pants, so I don't even do drugs.
We're in Amarillo, Texas for an arraignment.
Want your pants.
64-year-old Eddie Ray Gibbs has been charged with possession of drug paraphernalia. 2 days earlier, police responded to a criminal trespass call at a fast food restaurant. Gibbs was at the scene, and when police searched him, they discovered a glass pipe and small amounts of crack cocaine in his pants pocket. Today, he appears without a lawyer before Judge Laura Hamilton to enter a plea.
Now, he know damn well that's his. He knows that a glass pipe, a crack pipe, sir, that's yours, man. Why are we doing
Mr.
this?
Gibbs, how are you today?
Hi, Judge.
How are you today?
I'm blessed and highly favored, man.
Well, isn't that wonderful? So here's the deal. You've got this one possession of drug paraphernalia from July 8th. How do you want to handle that?
Blessed and highly favored. You sound like you
What my doggone pants?
What?
That's right. Gibbs is claiming the pants he was wearing, where the drug paraphernalia was found, do not belong to him.
They weren't my pants, so I don't even do drugs.
Gibbs makes his case to the judge.
My pants, they're all dirty, so I had to wear my roommate's pants.
How you think this argument gonna go, bro? I don't know how you think this argument gonna go, but I don't suspect it's gonna be well.
So you put your roommate's pants on.
Yeah.
And your roommate's pants had stuff in the pockets.
Yes, I didn't check.
But so who was in control of that situation at that time?
I was.
I know. I'm so sorry, Mr. Gibbs.
I understand. It's so fine.
But you can plead not guilty, no contest, or guilty. You're welcome.
Guilty because I had him on.
I know.
Yes, because you had them on. You can't put on pants with drugs in them and then you get caught with the drugs and then say they won't mind. Them your pants.
Well, but you can come in if you want to come in and talk to the prosecutor to see if you can work out a different deal. If you are concerned about the conviction, you're not concerned about that?
I have pants. So I'm accept whatever the consequences are, ma'am.
Didn't you tell me you're a preacher?
Well, I am trying to preach the word. It's called Divine Fellowship of Love.
Well, I don't want to do anything that's going to negatively affect your ability to do what you want to do that way.
Yes, ma'am.
So if you want to come in and talk to the prosecutor, maybe she would offer you deferred. You'd have to pay some money up front.
No, ma'am, Miss Plant, all I want to do is get it over with. Like I say, they wasn't my pants. So what? I accept what it is, and I'm ready to just move on and get my life right. My life is right. I'm doing God's work.
I guess from in my
Now you're doing God's work. No, don't bring God into this, motherfucker. Don't you bring God into this. Y'all can't stand y'all when y'all. Don't you bring God into this mess.
my mind and in your mind, God knows. God knows.
God knows. Don't bring him in.
Okay. So are you pleading guilty or no contest?
I'm pleading.
Despite Judge Hamilton's advice, Gibbs sticks with his plea.
I plead guilty.
Okay. Okay, I'm going to find you guilty, and I'm actually going to time serve you on this. So I'm going to give you the benefit of the doubt on that. I am going to adjust your fine to $219. Your court costs are $81. Your total's $300, and you are time served. Okay?
Yes, ma'am. And I'll be there at 2 o'clock today, tomorrow.
Nope, you're done.
Gibbs doesn't seem to understand that the judge has sentenced him to time served and that he's
I'll be there at 2 o'clock tomorrow. No, get the hell away from here. We don't want to see your punk ass no more.
free to go after paying his $300 fine.
You don't even have to come in, okay?
Well, amen. I love you.
Thank you. You have a good day.
Pay that money.
Thank you, Mr. Gibbs.
Thanks for being a fan of.
As long as you pay that money, we don't give a damn what you do. We don't care what you do. You can look. You can that just long as you don't bring your ass back up here. I don't want to see you no more. You know what I mean? I don't want to look. You know what I mean? Like I said, I don't want to hear that shit no damn more. You know. Now, don't y'all get pissed off when people interrupt y'all? I know I do sometimes. People interrupt me. That shit gets on my nerves.
Don't even try to get down, sir.
What you think a judge think when somebody interrupt? What you think? What would you think if you were a judge and somebody constantly interrupting you? Like, what the hell?
I'm going to find you in contempt for interrupting the court.
We head to Ann Arbor, Michigan for a pretrial hearing.
They're always in Michigan, bro.
34-year-old Shihab Jackson has been charged with possession of a firearm by a felon, carrying a concealed weapon, and resisting and obstructing a police officer.
Damn, he got a lot.
I'm going to find you in contempt for interrupting the court.
We head to Ann Arbor, Michigan for a pretrial hearing. 34-year-old Shihab Jackson has been charged with possession of a firearm by a felon, carrying a concealed weapon, and resisting and obstructing a police officer. He pled not guilty and was released on $10,000 bond. Today, he appears with his public defender, Lauren Brown. Judge Cedric Simpson presiding.
Your Honor, my client respectfully requests that this matter be set for preliminary examination at the earliest possible date.
April 4th, 9 a.m. before me.
Things seem to be moving along smoothly, but the defendant has a question.
What happens before now and then with concerning bond?
You're out on bond now, Mr. Jackson. Is there some aspect that you want to have addressed?
Yeah, I have to. Well, it's Ramadan right now, and I have religious obligations as well as work obligations in general. And it wasn't a drug case or have anything related with drugs. Like I don't see the reason for being on for drug testing. He's on
intermediate supervision. I'm disinclined to change that at this point. I'm not sure why Ramadan would interfere with his testing.
Well, it's not celebratory, sir. I just fail to see the connection with the nature of my case and having to go out of my way and pay money that I really don't have and time that I don't have to drug test on this matter. Especially
that's not a basis for me to change it. I'm not changing it. I'm going to leave his bond as continued. We can see him on the 4th.
Thank you, Adam.
But Jackson does not seem to want to let the matter go.
So is it not possible to amend the drug testing, Your Honor? Is it different? Is it just
Mr. Jackson, stop talking.
I can't hear. I'm just seeking clarity, sir.
Mr. Jackson, stop talking.
Stop talking.
I'm not talking.
So, see, it's that attitude that's the problem. So, what
Sir,
I'm going to do is I will. You need to be quiet.
I am.
No, we not.
Sir?
Mr. Jackson, let the judge talk.
I understand. I'm not sure if this was a mute or something. I'm just making sure. I understand.
Okay, so you don't have to respond to everything that's said. You don't have to get the last word. That's not.
I'm not trying to. My life is on the line here. That's all. That's all I'm.
Okay, you know what? Put some deputies at that door right now. Because apparently he doesn't want to listen to his attorney. He doesn't want to listen to me.
Sir, I'm just seeking clarity on the matter. That is all. I promise. I'm
too late now.
Black man in the system, just trying to fight for his freedom. That's all.
Okay, so am I.
You done pissed.
So don't even try it. Don't even try it. Don't even try it.
Don't even try it.
Get down. Get down. Sir, I'm going to find you in contempt for interrupting the court. Mr. Brown, if you've got somebody down here, he can come in. He can see me in person. We'll wait for a prosecutor to get down here, and I'll deal with this in person. I'm passing it right now.
Judge Simpson decides he wants to address the case and the defendant in person. Later that day, Jackson physically appears in court beside a new public defender.
All right. It didn't seem to me, quite honestly, that the defendant was being cooperative with anything, and I didn't know what his problem was. And so I was considering revoking his bond.
Your Honor, I've had an opportunity to talk to Mr. Jackson, and he has indicated that he would allow me to do the talking today to demonstrate just what he's doing right now. And so with that, we are asking that Your Honor give him another opportunity to come into court on his own.
Nope.
Jackson seems to be struggling, though he remains quiet.
You just got to do better. There is no reason coming in here today that this should even be occurring. Tell you what, Ms. Gaines tells me that I should give you another chance, and Mr. Brown told me the same thing. These are these people you won't listen to, by the way.
Nope. See, now he's
But if
quiet.
they tell me to give you another chance, I'll give you another chance. But I'm going to let you know you don't have any other opportunity with me to mess up.
He being quiet. He shutting the fuck up.
Am I understood?
Get it yesterday.
Pardon?
He's gonna get it yesterday.
All right, his bond can continue. He can be released.
Jackson remains free on bond until his case is resolved. If found guilty on all charges, he could be sentenced to up to 12.
Never miss an opportunity to shut the fuck up. Oh, I learned that somewhere. Oh, one of my coaches. That's right. I told y'all about that story. Never miss an opportunity to shut the fuck up.
Years in prison.
Never miss your opportunity to shut the fuck up, bruh. You always take that. You always take it and run with it. Because, see, that's all he had to do. Shut his mouth, and now, boom. All right? Now, look, man. You know what I mean? Now, if somebody kill your peoples, of course you're going to be upset about it. Imagine if they were sentenced to 40 days. What?
to 40 days.
You be pissed off. I know I would be.
I've lived
I'd be pissed off.
every day of my life being forced to relive that night because he killed my mother in my front yard in front of my children.
We're in Ann Arbor, Michigan for a motion hearing. 39-year-old Michael Young, who pled guilty to failure to stop causing serious impairment, has been sentenced to 40 days in jail and 18 months probation. 3.5 years earlier, according to police, Young drove his truck off the road through a ditch and into a car that was parked in a driveway. Inside the car was 76-year-old Patricia Vital. She'd been visiting one of her daughters when the accident.
Think about that. Now, for that crime, he got 40 days and 18 months probation.
Accident occurred. Young called a friend for a ride and fled the scene before police arrived.
Oh, shit.
Patricia was taken to a nearby hospital, but died from her injuries the next day. With the help of eyewitness accounts, police identified Young as the driver and he was arrested. One witness claimed to have smelled alcohol in his breath, but Young declined to speak to police. And since too much time had passed since the accident, his blood was never tested for alcohol.
Oh, I was about to say that because he split after the scene. By the time they caught up with him, oh yeah, he's sober as a bitch. What y'all talking about? What y'all talking about? I don't know what you mean.
Young was originally charged with failure to stop when at fault resulting in death and failure to stop causing serious impairment. But the first charge was dropped when he agreed to plead guilty to the second.
Damn.
Today, Young appears before Judge Patrick Conlon, having only served
I know the family pissed. I'll be pissed.
half of his 40 days in jail. But because he's scheduled for shoulder, neck, and leg surgeries, which could require a lengthy recovery time, Young is asking the court to adjust his sentence.
You're asking for early discharge. You're still
if that was me, I would just serve the fucking 20 days, man, and just be quiet.
on the hook to serve 20 days in jail. So one possibility may be that if we were to waive this requirement that you serve the 20 days in jail, I would actually extend your probation and you would be on the scram in a GPS tether.
But the judge is troubled by reports from the victim's family that since the accident, Young has been spotted at the local bar while on probation.
Of course.
Can I comment on that? There's a restaurant. It's the only one. I don't know if you've ever been to Bridgewater. It's a tiny little town with.
I do understand that, but just remember, sir, we're here today because of the death of a family.
I understand. It's the only place around to go to lunch. There's nothing to do with drinking, and I understand. I mean, I feel for everybody here, and I don't know where else to go with.
You're asking for early discharge from probation.
But
I'm
see,
willing
Barb,
to
he was gone. They don't know.
Waive one of the
And too much time had
requirements
passed.
of probation that you serve another 20 days in jail.
The prosecutor, Jessica Blanche, is not on board with this solution.
But there are victims who have lost a family member in this
For
case.
sure.
They were under the impression he was sentenced to a particular sentence. He was to serve this amount of time. For them, there's this closure here, and now we're saying, well, let's be accommodating. He's going to the tavern, I get it. Oh, well, there's not enough places to be right. Well, you can get takeout. I mean, this is a serious offense where someone lost their life.
Like, you're 100% right, but is him serving 20 days in jail better guarantee that he's not going to hurt anyone else than extending his probation further with conditions to show that he's sober?
Can I say?
Not really, sir. After I hear from the victims, I'm either going to give you a choice or not.
Before Judge
You know,
Conlon makes his
sometimes you
ruling,
gotta be quiet.
Patricia's daughters address the court.
He got sentenced to 40 days. 40 days. I've lived every day of my life being forced to relive that night because he killed my mother in my front yard in front of my children. He didn't even stay until help arrived. He chose to run away. It feels like an insult to my mother's life and to my family.
I agree with my sister that 40 days, it is an insult. Yes, I know she was 76 years old and
that's
she
a
was
spit in the
older, but
face.
she had a lot of life left to live. It's a sentence which, in my opinion, was so lenient to begin with, and to be discharged early, it's just insulting.
After hearing their statements, The judge makes his decision.
In light of what the victims have brought to me, I'm not going to make any changes to your probation condition, and I'm not going to grant you early discharge. I'm going to deny the motion.
Young remains on probation and still must serve the remaining 20 days of his jail sentence.
Man, serve the damn time, bro.
Thanks for being a fan of Court Cam.
I mean,
subscribe to A&E
all you
to
gotta
never
do
miss
is
a
just
new
serve
video.
the damn
Catch
time.
full episodes on aetv.com.
Think about that. All you gotta do is serve the damn time, bro. Serve the time. You know what I mean? Once you serve the time, you know what I mean? Shit. You know how that is. You know exactly how serving the time is. You know what I mean? Just 20 days, bro. Look, man, you made out like a bandit on that. You know what I mean? You made out like a bandit on that. I bet if I were you, I'd be quiet. You know what I mean? But yeah, man, see, hey, you be rude to the judge, you might mess around, get your probation, your bond, everything.
Ass around, dragging it around like some unwanted dirty laundry.
Uh-oh. Sister. All right. Don't you be daggone snappy with sister. Sister, revoke your shit.
Next, we're in Detroit, Michigan for a progress review hearing. Over 16 years earlier, 37-year-old Robert Osborne was convicted of assault and battery and brandishing a weapon. He was sentenced to a year of probation. But because Osborne allegedly failed to appear at hearings, his case has lingered in the court for years, despite a warrant being issued for his arrest. Today, Osborne appears remotely before Judge Elenice Bryant to review his case. He's represented by a public defender.
So I'm going to set the matter for review, see if probation can find his file, see if we can figure out what he has done and what he has not done. Mr. Osborne is going to come back to the court March 6th. March 6th at 10 o'clock.
It seems clear the defendant is not happy with the judge's decision to continue the case.
He just waved the judge. Oh.
I'm sorry, what'd you say? Come on, speak your truth, Mr. Osborne, because we're tired of the case too.
Judge Bryant doesn't appreciate Osborne's comment.
He bladed his body to the court, turned his head from the court, ignored the court when I was talking to him. So I just changed my mind. He's tired of the case, and so am I. We're going to just adjourn the case till tomorrow. Mr. Osborne is going to come in person, and we're going to close this case out. Anything further?
Judge, is there any way the court would...
No, I'm sick of the case too. And so tomorrow, we're no longer going to have to deal with the case. It's going to be over tomorrow, 8:30 a.m. Anything further?
Not at this time.
The next day, Osborne returned to court, this time in person. And he has a
sister on your ass now. See
new
what
public
you
defender,
did?
Janice Stevenson.
Come on up, Mr. Osborne. So I promised Mr. Osborne that I was going to end his probation today. And today I am keeping my promise. The court is going to revoke the probation, sentence Mr. Osborne to 365 days in the Wayne County Jail on the brandishing and 93 days on the assault and battery. Sentences will run concurrently.
It appears the jail sentence has gotten Osborne's attention, and Judge Bryant isn't done with him yet.
You are convicted. You're convicted of assault and battery and brandishing. You have been an absconder from justice.
Damn. Now, how dumb can you be if those your convictions? You up there be huffing and puffing at the damn judge. Now she gonna say, "Oh yeah, revoke that shit. You can take your ass to jail."
You did not show up. You're the one dragging this out. You should have took care of this back in 2006. Finished this probation and went on about your business. You the one keep dragging your past around, dragging it around like some unwanted dirty laundry. You're doing that.
Well, I'm asking the court to give Mr. Osborne an opportunity to demonstrate that he does want this matter from the past, squarely and solely in the past, without having to go to jail for 1 year and 3 months. And I think he sees that right now. There's too much on the line to not be thinking before we talk, so that he can put this matter squarely behind him, Your Honor.
After a final argument from the defense, the judge reconsiders.
Mr. Osborne, you changed your mind? You want to deal with it now?
Yes, ma'am.
Oh.
Damn.
I'll go back to what I said yesterday before all of this occurred, and I'll set it for March the 6th at 10 o'clock.
Osborne did return to court as scheduled for his review, but a report indicated he never completed the terms of his original probation, which included 12 weeks of anger management classes and paying court costs and fines.
Let's get it done, all right?
Yes, ma'am.
So the judge,
my man in there, yes, ma'am,
sentenced Osborne to 6 months probation so that he can finally complete his terms. The case was adjourned until a later date when Osborne's hoping to be officially discharged from probation.
Ain't that a...
She got a big ass body with some little ass breasts. Do like a gorilla, bitch, and beat on your chest. Big ass body with some little ass breasts. Do like a gorilla, bitch, and beat on your chest. Silverback, 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 back, silverback, back, silverback, silverback, silverback. Bitch and beat on your chest. Silverback, silverback, silverback.
Wait.